had another question that was asked today, and I believe it's extremely important for me to actually have the answer to this question. And the question was, we had an employee who is working abroad for our company, but they came to the United States on a B1, B2 visa for a meeting, and then the COVID-19 happened, and now they are working in the United States. They're still working and being paid by our subsidiary abroad, but what is the responsibility of the US employer where this person is working on projects that are mixed between the US and the foreign subsidiary? Well, it is a complex question, and there is a lot of gray area, and a lot depends on the very specifics of the actual employment of the employee. However, what you would need to do as an employer is look at the handbook for the I-9, and the handbook for I-9 is very clearly stating that if the employer employs anybody who is not authorized to work in the United States, even as a contractor, even if they're paid for a different entity, but they're performing services that the US company is benefiting from, then they are knowingly employing somebody who is unauthorized to work. And that's something that would have to be very carefully avoided, because the US employers have to abide by the employment laws and regulations, and you don't want to be in an issue where you have to pay penalty. And yes, it is a very unique situation, and there are a lot of gray areas with the individual who is here that came for meetings and now pretty much stranded in the United States. But I would suggest that the employers stay very careful of the pathway to allow anybody work in the United States who are not authorized to work in the United States. I hope everybody is safe and healthy, and I talk to you soon.